Hello and welcome to Rights and Recourse, a program that informs and educates viewers about their legal rights and what recourse to take in case of violation. I'm your host, Dumila Matez. Road accident victims wishing to lodge a claim for the Road Accident Fund can expect a much more effective and efficient claim process. This is as the government agency fine-tunes its benefit system to improve the delivery of services to claimants. To discuss today's topic are Mr. Chris Willems, a Senior Manager, Regulation from the Road Accident Fund, Mr. Terence Gow, Road Accident Fund Project Manager from the Department of Transport, and Mr. Ronald Bobroff, a specialist medical malpractice lawyer from Ronald Bobroff and Partners Incorporated. But before we get into this discussion, let us have a look at this insert.
The Road Accident Fund claims had a notorious reputation. Previously, victims of accident faced exploitation by unscrupulous lawyers and a complicated claims process. But this experience is gradually coming to an end. Now, proposed changes to the fund's claim process are set to make things easier for victims. Now, qualifying claimants will not need the help of a lawyer to claim directly from the fund. While this has been celebrated, it has not been good news to accident claim lawyers as it closes a lucrative income stream for many lawyers. Recently proposed changes to the Road Accident Compensation Scheme promises to bring even justice closer. Within 30 days, victims will now receive medical treatment from the fund irrespective of whether the victim was at fault or not. The planned amendments to the Road Accident Fund laws also mean victims who suffer serious injuries will qualify for lump sum from the fund. And this promises convenient time and cost savings to the claimants. It is also hoped this will increase efficiency and ensure better service delivery, including the sustainability of the fund. Mbali Madigwa, Rights and Recourse.
Well, gentlemen, welcome to Rights and Recourse. Chris, let me start with you. How does the Road Accident Fund operate in its present form?
The Road Accident Fund is a statutory entity reporting to the Minister of Transport. It's established in terms of an act with the object to pay compensation to those injured in motor vehicle accidents. The current scheme is fault-based. What that means is that before a claim is paid, the Road Accident Fund must ensure that someone else or another driver was at fault or at least contributed towards the accident. In the event that the claimant was solely responsible for the accident, there is no claim. Or in the event that the claimant contributed towards the accident, that claimant's claim is reduced in proportion to his contributory negligence. Under the current scheme, a claimant is required to prove his or her actual loss. There's a process where a lot of service providers get involved in terms of determining what that may be. Once the loss is quantified, there's an offer made and hopefully there's settlement. Because of the fault aspect, however, these claims take a long time to settle, because as you can understand, where there are multiple drivers involved in an accident, every driver would want to see as small an apportionment of that claim as possible. So the current system there are challenges in terms of paying compensation fast. The fund is required to investigate negligence and fault. And also, in terms of quantifying the loss, there are a lot of, like I've mentioned, service providers involved in order to quantify what the claimant is entitled to. Unfortunately, there's a lot of litigation as well. So the court rolls are full of Road Accident Fund matters where the judiciary are required to determine disputes between the parties.
Let me come to something you said. If there's somebody who's found to be in the wrong, there is no claim that is being paid out. Isn't that what brings in the lawyers, Ronald?
Hi, yes, good afternoon. Well, I think we learn in life there's no such a thing as a free lunch. And in principle, if you say no fault, one would say, hurrah, every road accident victim has a claim. Problem is, the cake is only so large. And to compensate the drunk driver that turns you into a paraplegic or brain damaged person, to give him compensation, it's got to come from somewhere. And it's going to come out of your pocket. It's going to reduce the compensation available to you. And the analogy one has is we have our workman's compensation system, now called COIDA, which is in a state of collapse and chaos. I have done numerous interviews with regard to the state of that institution, and every few years government appoints another commissioner to solve the problem. And the problem is, because workpersons have no right to engage a lawyer and no one to speak up for them and no rights to approach the court, they get peanuts and their claims lie dormant sometimes for decades. So,
Isn't it also that lawyers are trying to look for loopholes in the Act, in the RAF law?
You know, the job of an attorney, and we go back thousands of years, we're probably the second oldest profession. I won't say what the first one is. Many would say we're the same. But the job of the attorney is to be the voice, is to represent the rights of the citizen. And whether you are bitten by a dog, whether you're assaulted by the police, whether you're the victim of a road accident, your rights should be the same. Namely, you should be entitled to receive fair and appropriate compensation, such that the amount of money you receive will put you in the same position, insofar as money can do it, as if you were not injured. Now, the Road Accident Benefit Scheme does the exact opposite, and I'll elaborate on that in a moment. It's bad news for road accident victims.
Well, I just want to come to you, Terence. Terence, why was it necessary to convert the RAF to the Road Accident Benefit Scheme Administrator? Does this have anything to do with the liquidity of the RAF?
Well, one's got to look at when government became involved, and this is a long process. It started in the 1990s. The government published 2 white papers. A commission of inquiry was appointed.
Sorry, Terence, is this what used to be called the MVA?
It is essentially what used to be called the old MVA fund. We have a system which came into effect in 1942. Well, the legislation in 1942 came into effect in 1946, has been in various forms. So in 1999, government appointed a commission called the Road Accident Fund Commission, headed by Judge Kathy Satchwell. And the commission made various recommendations, following which Transport then published various papers, including a strategy paper in 2006, 2 policy papers, with the final policy paper being approved in 2011, and went on now to publish 2 draft bills. This is the second draft bill that has been published. So it's been an ongoing process.
Chris, the other thing I want to know, how much of these changes to the RAF are as a direct result of the role played by personal injury lawyers?
I think, or I can state that if you have a look at the preamble of the Road Accident Fund Benefit Scheme Bill, one of the reasons for having to move to a new dispensation is the fact that the current Road Accident Fund isn't achieving the objective for which it was created. Partly because a lot of the money paid in administering claims is spent on a service provider industry, and in that money is now not reaching the intended recipient, which is the claimant. In the last financial year, the fund, as an example, had spent 1.2 billion rand on medical cost. So claims for medical costs was paid at the tune of 1.2 billion, whereas the associated cost in terms of litigation and experts was 4.6 billion, almost 4 times what had been spent on medical compensation. Now clearly that doesn't reflect a healthy system, and that underlines the fact that the current scheme is ineffective in getting benefits to beneficiaries.
So you're saying some of the claims were not reaching the claimant?
The point that I'm making is that in terms of the funding that the fund receives, if the object is to pay compensation to motor vehicle accident victims, as much of that funds that is received by the scheme should flow out to victims. But if you compare medical expenses against litigation cost, the fact is that almost 4 times less is spent on compensation for paying the medical treatment of claimants as opposed to paying attorneys, experts, to prove those claims. That is inefficient.
I want to move quickly through what we have to discuss today, but I want to just find one more thing. Why is there, I've always wanted to know, why is there such an adversarial relationship between the RAF and the personal injury lawyers? Ronald probably can answer that.
Well, it shouldn't be. We should really work as a team, and I must say that one would like to resolve claims as soon as possible, but sadly the experience, certainly during the recent past, is that the Road Accident Fund simply ignores claims. They have a moratorium of 120 days after you lodge a claim, during which you cannot serve a summons, and during which time the Road Accident Fund is supposed to investigate the circumstance of the accident, the injuries to the victim, and ideally make some sort of an offer. It never happens. If you get an acknowledgement receipt of your claim, you're lucky. You serve a summons on the Road Accident Fund, once again, it takes ages before you get a response if they appoint an attorney. And sadly, the situation is so bad, this can be confirmed by reference to decided case law, that you get to the actual day of trial, and the firm of attorneys representing the Road Accident Fund, not all, but many, will come to court without a file and will say to the plaintiff attorney, can you give me a copy of the claim form? Can you give me a copy of whatever? So unnecessary litigation costs are built up simply because of inefficiencies within the fund itself. Now the fund, before the creation of the Road Accident Fund, the insurance was provided by a consortium of private insurers. Now, as we know, private enterprise is driven by a profit motive which creates efficiency. So, for example, it would be Santam, Rondalia, President, and whichever. And there, the private insurers had their own attorneys who were really smart, and the claims were administered properly. Most claims were settled. You didn't have this long, drawn-out, costly litigation process. So, I think it's unfair to lay the blame at the door of the attorney representing the victim.
We'll come to that, Ronald. If you'd like to join us on today's discussion, you can tweet us at Rights Recourse or email us at rightsandrecourse@sabc.co.za. We'll be back after the break.
Our new waterproof smartphone takes superior photos even in low light. Has PlayStation 4 remote play and up to 2 days battery life. Don't settle for good. Demand great. The new Sony Xperia Z3 series.
Cultures of Africa, though similar in some ways, are colorful and diverse.
We explore the rich culture, dance and dress of the Tanzanian people of the Mtwara region.
The dance that they're performing is what you will find in the village. And it's not just a paid gig, it's something they do, they enjoy.
Mtwara's late development has left it with a rich reservoir of empirical knowledge of a pure African life.
For whatever the reasons are, it's one of the last areas of the country to develop, and thus traditional arts and traditional culture.
That's Kaleidoscope, Sundays, 5:30 p.m. on SABC News.
Zoom into Africa. This is Malawi. The president is Professor Peter Mutharika. Malawi got independent from the United Kingdom on 6 July in 1964. The population is more than 15 million people. One of Malawi's major languages is English. Monetary unit, Malawi Kwacha.
President Robert Mugabe began a state visit to China on Sunday in a bid to lure investment in his country's stagnant economy. President Xi Jinping hailed Mugabe as a renowned African liberation leader.
Proudly, South Africa is indeed pressing on with its Ubuntu School campaign, launched in 2012.
Somehow, as South Africans, we have drifted from the core of who we are. We have kind of lost a sense of identity.
The program aims to address the rising levels of sexual violence and bullying at schools.
You find the amount of hooliganism and sexual violence in schools. So it's actually quite disturbing. And the challenge is quite huge.
PM News every day, 3 to 5:30 p.m.
Welcome back. Terence, quickly, how will RAPSA, as it will be named, fit into a picture of social security? In other words, how will you change an insurance-based system into a social security system?
Oh yes, Dumile, it's based on insurance and DELIC, the current scheme. We move away from the delictual side. We remove the fault requirement, and we move to a scheme where you receive defined and structured benefits. So we no longer focus on exactly what you have lost. We now focus on what the scheme can provide. So it's a question of what can the scheme provide, what is the benefit that's defined, and you use a formula and you come up with a result. If you have a particular income claim, for example, you would apply a formula and you would know what you should get.
Well, I read through that formula. It's quite a difficult formula, and I wonder how a person, a lay person like myself, I couldn't even go through that formula. How do you calculate that formula, Chris? It is very difficult. I saw it.
No, sure. And it's more difficult if you don't have it in front of you. So I think that question is unfair at this point in time. But I can say that in terms of the provisions of the proposed scheme, there's an obligation on the administrator to assist claimants to claim. And there would surely be officials that would be willing to take a beneficiary through the formula and explain it to them. In theory, it should also not be that difficult to determine what your benefit is, because in terms of this formula, you feed it a figure in terms of your income, proven income, or a deemed income. So even claimants who aren't earning anything, who may not have a claim under the current scheme, may actually have a claim under the new scheme. And that deeming income will be fed into the formula. It will give you a defined benefit. It's basically a calculation based on how long you're impaired, divided by the number of months, and the structured payment is made until such time as you are rehabilitated, if at all.
I'll come to you, Ronald. I just want to just ask something else that I wanted clarity on. When I was doing my research, I came across the social security benefit that is spoken about in the Act. And one of the things that is being said, people will not be allowed to double dip in government funds. In other words, if I'm receiving a grant and I then was involved in an accident, in other words, there's a possibility I might not be paid by the administrator. Is it true?
The administrator, in terms of the proposed legislation, does not, or the bill doesn't deal with SASSA at all. The fact, however, is that the benefits received from SASSA are received based on a means test. So in the event that you do receive a benefit from the new administrator, there is a likelihood that that benefit may cease. The point of the matter is, however, that you will be receiving a benefit, and the state cannot afford you to be doubly compensated.
What do we mean when we talk about a fault-free based system?
From an administrator or from a claimant perspective, what it means is you're entitled to a benefit irrespective of your contribution or otherwise to the accident. You're sure that there's a safety net. You are going to receive medical treatment. You may receive an income benefit in the event that you were injured to such an extent that you cannot work. You'll be looked after, and the emphasis under the new dispensation would be rehabilitation. So the intention is to treat the person and get him back to work, irrespective of your contributory negligence to the accident. Because you must understand that under the current scheme where, let's assume you are at fault, you wouldn't have a claim against the road accident fund, but you will then have to be looked after by other entities or social security systems funded still through tax money.
But surely the way you explain it, Ronald, there's been a little bit of unhappiness from the legal profession on this matter, and especially the manner in which the RAPSA was going to be put together. And I think there's still a role to play for, in the way he explains it, there's a role to play for lawyers here.
Jimmy, if you'll permit me, I don't think it's a lawyer issue. It's basically a human rights issue. And if you permit me, let me present the situation as it exists in other countries and as it exists in South Africa if a victim sustains injury from a cause other than road accidents. And then let me compare that to what RABS proposes. And then you and the viewers will decide if RABS is good news for road accident victims. If I am assaulted by someone, or I'm the victim of someone who attacks me and I suffer an injury, I'm entitled at law, obviously I have to prove fault, because there is a morality inherent in our law. You should not benefit from your own wrongdoings. If you get blind drunk and you collide with a tree, well, should you receive compensation? That's a moral question to be decided. In most civilized countries, the answer is no, or perhaps just a minimum level, perhaps, of medical care. So if I suffer an injury from any cause, in terms of law, I can sue the wrongdoer and I can recover my damages. Now, what are those damages? I'm entitled to first world private health care. RABS removes that. Effectively, it's very hard to understand. It's mumbo jumbo. And as a lawyer of 40 years experience, I had to read it 5 times. And I still don't know what it means. But my conclusion in it means you'll be lucky if you get anything remotely above state care. We know our health state facilities in South Africa are severely challenged. So firstly, you're deprived of private medical care, number one. Number two, if I'm earning 20,000 Rand a month and I can't work because of the injury sustained by the wrongful act of another, I can claim that 20,000 Rand a month for the time that I'm not able to work. If I lose out on promotion prospects because I was a young actuary or a young doctor or a surgeon and I had tremendous promotion prospects and I could have earned within 10 years 2 million Rand a year, I can have that actuarially calculated and I can claim and recover the amount of my actual loss of income. So basically my life as it would have been income-wise, I am compensated for. RABS takes that away. It limits it to a maximum of approximately 200.
Let's give Chris a right of reply. Chris.
Yeah. Well, if I just go through the whole...
No, you will go to that. Okay. We'll go to as we go along.
Categories of damages, which if you just let me go through, only 2 more. And then certainly Chris can
let's hear that.
Okay, so we've dealt with medical expenses. All you get here is state health, no private care. Number one. Number two, you don't get your actual loss of income, you get the caps. It's about 226,000. That's it. If you are supporting your family on 30,000 a month and struggling to come out, too bad. Where can you get the 10,000 Rand a month extra to survive? You can't, because your right to sue the wrongdoer is taken away. Finally, your estimated future medical expenses, in terms of the common law and in terms of the situation which now prevails, you're entitled to private health care for the rest of your life as of right. RABS takes that away. RABS takes away all benefits when you reach age 60, at which point I suppose you're supposed to commit suicide. The widow that's lost her breadwinner, when she hits 60, she only gets benefits for 15 years, and then it's just too bad. It's a heartless system.
Let's give Chris a right of reply. Chris?
I think there's some aspects in there that I would like to respond to. The first one is your common law delictual claim against, let's assume you get assaulted. If you're assaulted by a man of straw, now in law that means someone without means. You've got all your rights. You can sue this person until kingdom come. You can get you can get an order against him. But if that person doesn't have any assets, that order does not mean anything to you. You will not get compensation from that person. So it's one thing to say, at law it would be nice to have a common law claim. But if that common law claim is empty in terms of the person you're pursuing the debt from, it's useless to you. Now, in the Constitutional Court, in the 2008 amendments when they were challenged by the Law Society of South Africa and others, the court went there and they considered this argument. In terms of the common law claim that was done away with, the court had made this comment as well, that what we need is a social security scheme that ensures at least minimum benefits, so that you do not as a claimant land up in a situation where you have all your rights, but you don't have a defendant with the money to compensate you. So that's what happens in terms of common law. Let me just come back in terms of the benefit scheme, benefits in terms of medical treatment. Nothing in the bill specifies that you'll be entitled to provincial health treatment only. Quite the contrary. The bill provides that the administrator can contract with medical service providers. It is anticipated that will include private medical healthcare service providers. There would be, it's anticipated, a whole network of these contracted with. So as a person injured in a motor vehicle accident, nothing is in the bill or in any of the regulations published or the rules with the legislation that was published for comment provides that you would only receive a benefit at the level of provincial health.
I see Terence who wanted to jump in there. Let's hear what Terence has to say. I'll come back to you, Ronald. Let's hear what Terence has to say.
Yeah, if I can clarify from a policy point of view, Dumile, government is saying that all people that are on the roads are paying the same contribution to this pocket of money that's being used.
You're referring to the fuel levy.
The fuel levy. So we're all paying the same at the end of the day. However, what's happening is that there's a large percentage of cross-subsidization, which now has been addressed to an extent anyway. The example quoted by Ronald of the person earning 2 million rand a year, that's already been dealt with. There's already a cap in place, and this cap will mirror that cap. So that's roughly the same. However, we can't have a situation where we are cross-subsidizing the rich by the contributions of the poor, when we know that the statistics show that there's a very small percentage of people that earn in excess of 220,000 rand a year.
Going to that, I think Terence has brought us to a point where I wanted to ask the question of, apparently if you earn above a capped amount, you are perceived to be one of the 4% of the population in the country that are defined as rich, and you will have to make provisions through private insurance, but perception and reality are two different things altogether.
There's an actuarial statistic, and this was the actuarial calculation was done when we amended, or when the 2008 amendments came into effect. It was more recently confirmed that only 4% of the population between the ages of 18 and 65 earn above the cap. So the majority of the population would not be impacted by having this cap. That 4%, it is not unreasonable to expect of them to take up top-up insurance in terms of benefits not provided by the scheme. Government and the scheme cannot afford open-ended liability in terms of benefits, more especially in a no-fault scenario. You cannot pay benefits to everyone on an open-ended basis. There needs to be controls, caps or limits in the scheme, and that's what the upper cap does. It limits claims for income benefits.
Well, if you'd like to join us in today's discussion, please tweet us at Rights Recourse or email us and give us your views on an email, and also tell us what topics can we cover on Rights Recourse at sabc.co.za. We'll be back after the break.
Slow motion playback on our new waterproof smartphone. Don't settle for good, demand great. The new Sony Xperia Z3 series.
Demand great and get the waterproof Sony Xperia Z3 compact smartphone with a 4.6-inch display for only 449 Rand per month on a Smart Small contract this summer. Vodacom. Power to you.
This former breadbasket of Africa, playing host to SADC leaders.
I feel humbled and yet greatly honored at being appointed the chairman of SADC.
When I was a student, Harvard was only my visible college, my formal classes, but I was also a student in an invisible college.
The outbreak in West Africa is the world's deadliest to date. It's centered on Guinea, Liberia, and Sierra Leone, with cases also reported in Nigeria.
Catch news at 8, 7 days a week. Be informed.
Healthy food is not always the cheapest food option, and so making the healthy choices, the easier choices, remain a health challenge for South African children.
Bipolar disorder is said to affect 1 in 100 people.
Low back pain, the most common spinal disorder, affects about 8 out of 10 people at some point in their lives.
Back pain persists for more than a week or two. Seek advice.
I'm Dr. Sello Madaou. Watch Health Talk every Saturday on SABC.
Welcome back, and we continue our discussion on the RAPSA, the new body that's going to take over from the Road Accident Fund. Ronald, you had something during the break. You spoke about people cannot get insurance because you've got to cap up with personal insurance.
Exactly. The Law Society and the South African Association of Personal Injury Lawyers investigated this thoroughly at the time the amendments came into effect, the 2008 amendments. And the insurance industry got very excited. They were the only party in the parliamentary hearings at the time that supported the proposals because they were gleefully rubbing their hands and they thought, well, here's coming a waterfall of income. You can't get insurance. Firstly, you can't get insurance without a medical examination. If you're a person living with AIDS, it's excluded. If you are a person who's earning a modest income, for example, say a student or someone who's just started in their career, you can only get insurance for loss of income based on what you're earning now. So if you have a 25-year-old medical doctor who's going to earn a lot of money in his or her life going forward, all he can get insurance for is the nominal amount he or she earns as an intern. His life is destroyed tomorrow by some drug driver, tough. You cannot get insurance for a family of 4 today for R1 million for the whole family for less than 12,000 Rand a month. Now, I don't know how many South African families can afford 12,000 Rand a month. It's not available, number one. Number two, excuse me, you need to have perhaps a solution. Now, one can understand government might say, look, the current system is unaffordable. The fuel levy is at the level that it is currently, and with that money that's available, we can only provide...
more and more things are likely to be added to that fuel levy.
We can only provide benefits to a certain level. And for example, you have dual systems in certain states of America, in Canada, and in Australia. And those dual systems make provision that you have a basic level of benefits, but the common law right to sue the wrongdoer is retained, and people take out insurance for that. Because there's a basic level provided by the state, the cost of that insurance is very affordable. So what the Road Accident Fund needs to do...
Let's address from Chris and Terence, both of you can probably comment on this common law right to sue the person who has committed the wrongdoer, who has made you cut off your legs because of an accident and you can't work, that you can sue. I know you made the statement early that you can sue a man who doesn't have a penny, you'll not get that money.
Let's take the example. Let's assume that man is you. You've got a home and you've got a family. So you're someone with means. So the person without the legs, in this instance, is lucky in that he has someone that he can pursue who could potentially compensate him for damages suffered. Now your house is sold, your children can't go to school, your salary is attached. It has an impact on you as well. So from a society that should be looking after one another, is that something we would want? And I don't think it is. I don't think any of us want to be traveling on the roads knowing that our assets, our livelihood is at risk. And not everyone can afford insurance. And just on the previous point, after the 2008 amendments, there are products developed for this, and we've checked that there are those products available. So you can get top-up insurance in the market.
We'll make it available for the next show. We'll probably put it online.
I think it was a perception that Chris was talking about. I am not a man with a lot of money. Let's come to Terence. Terence, the other question is, are we likely going to see a fundamental change in the way the Road Accident Fund is run now and the manner in which RAPSA will be run? In other words, will RAPSA have a board of directors, as is the case with the RAF?
Yes, there'll be a board very similar to what the Road Accident Fund has. The bill provides for a board, and it provides for various transitional provisions on how you move from Road Accident Fund to Road Accident Benefit Scheme. To come back to the insurance question as well, Dumile, the Road Accident Fund is in a unique position because it pays without there actually being a wrongdoer identified or on the scene or found, because the Road Accident Fund pays for people that are knocked down in the road or on the side of the road by unknown drivers in the dark who don't stop and move on, and no one knows who they are. Now, your common law right doesn't help you in that instance because you need to be able to sue someone. And Road Accident Fund currently, and the Road Accident Benefit Scheme, when it takes over, will take over that role as well. So it's not simply a question of finding someone and suing them. It's very difficult. in addition to finding someone with money.
Chris, I understand the Road Accident Fund has conducted extensive consultation which would be across the length and breadth of the country, informing your clients about the changes from REF to RAPSA, and how are these consultations received?
They're received differently from different perspectives. From the legal profession, the RAPS bill is receiving a lot of opposition. It's to be understood because there's a financial interest in retaining the status quo. I've heard that there's something referred to as a Contingency Fees Act, and an attorney acting for a claimant has an interest in the benefits paid or the claimed amount settled for. So in pursuing no fault, the role of attorneys are reduced because there's no longer disputes around who's at fault. Benefits are defined. It's not to say that there can't be any disputes, and it also clearly the Act doesn't exclude a beneficiary from procuring the services of an attorney, but the role is definitely reduced. And from that perspective, we've heard many comments to argue for retaining the common law claim, even as a top-up level, as suggested by Ronald earlier, because that then keeps alive the profession in terms of the financial interest is still there.
Apparently, there are stringent measures to disclosure by any member of staff of RAPSA, should they disclose any information regarding, I would imagine it's the same with RAF, with the RAF, that should they disclose any information regarding a claim and beneficiary acquired in the course of the application. Can you explain some of these measures? Apparently, transgressors could be found guilty of an offence and could face a conviction of 50,000 Rand, of more or less 50,000 Rand.
Well, the intention is to safeguard information, Dumile. Road Accident Fund currently and Road Accident Benefit Scheme will deal with sensitive personal information. They will have medical information, they will have details of your income, which you will provide to them. And that must be dealt with in a safe and secure manner. And there's even legislation which has been discussed, which will come into being, which will deal with what can be disclosed and what can't. And Road Accident Fund and Road Accident Benefit Scheme must protect and does protect the information that it has in order to protect the public.
I understand there's a 30-day period in which to submit your claim. If there is this 30-day period that we do to submit a claim, and I'm lying in hospital for 60 days, and after 60 days I can't come back and claim, isn't it?
Can I maybe just rectify that perception? You have 3 years in which to lodge a claim under the new scheme.
Oh, 3 years?
3 years. In the event that for whatever reason, let's assume you're in a coma for the 3 years. The 3 years would not start running until such time as you come out of the coma. So you don't have to fret, it's not 30 days. There's ample time to submit a claim. And if you read that into the obligation of the administrator to assist claimants to claim, in the future dispensation, there would also be processes in place to try and trace and assist those claimants even before they even might have thought about claiming against the Road Accident Fund. You could appoint a curator in that instance, and a curator could manage the claim on behalf of the person who's unable to do so.
A curator could be a lawyer?
It could be.
So there's still a role for you to play?
There is no role of substance for anyone to represent the interests of a road accident victim in terms of RABs. It's a purely administrative system. The courts are excluded. The right of the victim to have an examination by an independent medical practitioner, to lead evidence before an independent judge as to how that victim's life is to be affected, that is removed. There's no basis to pay the cost of such an expert, and the role of the court is excluded. The sole remedy for an aggrieved claimant is a review to court. That's virtually impossible because you have to show fraud or that the administrator didn't play his or her mind. It closes the door to justice, it closes the door to the courts. And ask yourself this question. It's not a legal issue. Yes, attorneys have an interest, but let's divorce it from that. Let's talk about human rights, the rights of victims of any form of personal injury. Why should road accident victims be discriminated against as opposed to victims of all other forms of injury? Medical malpractice victims, victims of shootings, victims of faulty products. It's unfair. And as I've said, I can understand one can provide a defined first level of benefits, but you cannot and should not exclude common law rights. Because take your example, and I'm not going to ask you what you earn, but let's assume you're earning 35,000.
Don't worry, I earn validly.
Well, I'm sure you do. We know that 3% of South Africans pay 88% of all taxes. 3% of South Africans pay 88% of all taxes. So it's the economically active captains of industry, those that generate the revenue that supports the balance of of citizens. 97% of South Africans are supported by 3% effectively direct taxes. Now, how will a breadwinner who earned 30 or 35 or 40,000 rand a month, which is not uncommon today, who will never work again because he or she have lost their legs or is a paraplegic or a quadriplegic, how will they survive and support themselves and their family on 20,000 rand a month? They can't claim from anybody else. There's no recourse against the wrongdoer. There's no recourse against the road accident fund. How will they survive?
The question that was raised by Ronald, he's answered one of my questions, because I had a question that asked, can this be reviewed by a court of law, the decisions of this? But we'll come to that after our first question will be my next question. But if you'd like to join us on today's discussion, please tweet us at Rights Recourse or email us on rightsandrecourse@sabc.co.za. We'll be back after the break.
A gloomy Christmas for many South Africans whose jobs are on a knife's edge.
But the concern this time around is that there's certainly a spike and all sectors of the economy face risk.
Solidarity is involved in 45 different retrenchment exercises, and it cuts across all sectors.
While most retrenchments are expected in the mining and manufacturing sectors, analysts say the public sector will not escape.
So people are now sitting on their hands because the future is very uncertain.
Primetime News, daily at 6 p.m. on SABC News.
Welcome back. Gentlemen, we are still discussing the Road Accident Benefit Scheme Administrator. The question I wanted to ask is, many lawyers I've spoken to the Black Lawyers Association. I think Ronald alluded to that. I think I read somewhere when I was doing my research that some of the lawyers are saying this bill could be unconstitutional.
They would. Of course they would say that. they said that in 2008. They took it to the Constitutional Court, and there were 3 issues decided by the court. 2 of them they lost, one being the common law claim. The Constitutional Court in that matter ruled that it is fine for the common law claim to be taken away. Now, the same argument arises here. For an obvious reason, we've referred to the financial interest. So it's not always about the claimant here. It's about vested interest in retaining an income. So that argument will be made, I'm sure, on a future date, and I'm confident in terms of the outcome.
My next question after this one, I just want to go back to you, Chris, again. What would be the procedure for claiming by claimants in an accident if lawyers are not to be involved in the process or to assist them?
Okay, just to make clear the point. Nothing in the scheme rules or in the bill excludes representation by an attorney. But the new scheme emphasizes and places an obligation on the administrator to assist those claimants that are entitled to benefits to lodge their claims. They will be taken through the claims process, they'll be sent for assessments. One of the benefits, the medical benefit for instance, provides that the cost of those assessments is paid by the administrator, so that you don't need financial means as a claimant to prove a claim. So the administrator takes your hand, takes you through the process, pays for your assessments, determines what you're entitled to and pays you the benefit. If you require vocational training, they'll provide vocational training. If you require services to rehabilitate you, they will provide rehabilitation services. If there's an income that has been lost, there's an income benefit. But the emphasis in the new scheme is to get you back to work. It's not to perpetuate the situation where you are reflected as someone that could never be economically active again and just sit back.
What if I don't become economically active?
If there's a medical reason, if it's not possible for you to re-enter a labor, sure, then you get the benefit. But if you don't participate, for instance, in that rehabilitation program, or if you deny treatment, if you remove yourself from a situation of where you could be treated, where you could be rehabilitated, there are provisions in the bill for the administrator to suspend that benefit.
Terence, the other question here, apparently the Minister of Transport can change the terms of the long-term benefits and may prescribe any ancillary or incidental from the proper implementation of this Act. This will be done by the Minister on what basis and how?
The bill provides for in the form that it's been published, the bill provides for the minister to adjust benefits to aid affordability. In other words, once the scheme is up and running, it will then be possible to see exactly what it costs. And at that point, then the bill says that the minister can then adjust the benefits. Obviously, as well, there will be instances where it would be preferable to increase those benefits to allow for factors such as inflation.
If I may just come in on the constitutional aspect, with respect to Chris, RABS is not the same animal and benefits as is and was the Road Accident Fund at the time of the constitutional challenge, which I was proud to be associated with because it brought dignity and life back to road accident victims. It restored the right to private medical care. Seriously injured victims die in state health facilities. That is still the case. Now, the current scheme provides private health care. It provides a lump sum in respect of all heads of damages. So your past loss of income, your future loss of income, the compensation for the pain and suffering that you suffer, all of that is payable to you in a lump sum. So you can get on with your life. You're not forever dependent every month to go to the queue, put your hand out and say, well, am I going to get a payment this month? Or is the administrator going to decide, well, Mr. Brown, can you hop on one leg? I want to see if you've recovered sufficiently. Or Mrs. Chabalala, you're looking very pretty today. You should be able to find a husband and really don't want to continue paying your loss of income. I'm not being facetious because that's what the Act provides for. It was a different animal. And whilst with respect, I didn't agree with the Constitutional Court's decision, I can understand its reasoning. Now, RABS doesn't provide lump sums in respect of loss of income as of right, and only in exceptional circumstances will it provide some form of lump sum. And as I've mentioned, for reasons which I've never understood, and perhaps my colleagues here can explain, all benefits stop when you reach age 60. Well, I'm long past 60, and so what do you do when you hit 60? Is it time to get to the box? What do you do?
Terence, you wanted to weigh in there.
I think we need to, bring about a correction in the sense that the Road Accident Fund Amendment Bill at no stage removed the right to private health care. It placed no restrictions on that. The judgment of that court only related to a tariff, and it didn't affect anything except the relationship in terms of what the Road Accident Fund had to pay those medical service providers.
It provided private health care at private rates. That wasn't the case before.
It's the tariff.
Gentlemen, I'm sorry, we have to go to a break or they'll cut my neck off. If you'd like to join us, please, in today's discussion, you can tweet us at Rights Recourse and email us on rightsandrecourse@sabc.co.za. When we come back, we'll be talking about dispute resolution. How can we do these disputes if there's a problem around these issues? We'll be back after the break.
Had there been harmony between the South African government and the Nigerian government, which came through in the latter stages, the bodies would have been repatriated quicker.
Now, we always get a lot of criticism as a public broadcaster, but just how far can media go in terms of reporting the facts?
Watch Media Monitor Sundays at 9 a.m. on the SABC News Channel.
Welcome back. Let me go straight to Chris. Chris, the question I wanted quickly before I go to dispute resolution was on the clause on limitation liability. Apparently, the administrator or any official employed by the administrator shall not be liable for anything or omitted to be done in good faith in the exercise of any power or any duty conferred or imposed by the Act unless wrongdoing can be proved. I assume proved beyond reasonable doubt, but the question is why?
The issue is you need employees. And in terms of the litigious environment where we currently operate, you're not going to get those employees to work on claims if they could, in their personal capacity, incur liability. So the administrator would certainly deal with those infringements in terms of an internal process. But the clause as it's worded there, we are advised, is in line with the common law administrative position.
There's another question I wanted to ask, and that has to do with, apparently in the general provisions of the Act, the driver of a vehicle in a road accident, and if the driver is not the owner must provide the administrator with the details of the accident within 30 days. Goodness me, if I was not driving the car, how can I know what the details of the accidents were?
If you've lent your car to someone and he returns it to you without a bumper, you're going to ask questions. You're going to certainly inquire as to what happened. From the administrator's perspective under RAPS, that information would be used to originate claims, to assist claimants. There is a similar provision in the current Act, but that's used to establish the identity of your insured driver, to investigate the issue of fault. So it goes to liability and determining claims. And there's, in other words, a difference between the two provisions as opposed to what we currently have and why we have it in the RAPS. So in the RAPS, it's to identify potential beneficiaries.
I'm not at all trying to say, Ronald, that the Act was put together so that we can get the lawyers out, but reading the Act, going through the Act, I somewhat found the process could be confusing and cumbersome to the ordinary man in the street. How is the ordinary man in the street going to do the involvement of legal practitioners is unavoidable?
Well, the sad answer is attorneys will not be able to assist claimants because there's no basis to recover fees. And, a man's got to eat. And in all professions, you have to receive reasonable remuneration. Now, if you look at the Workmen's Compensation Act.
What is reasonable remuneration?
We'll come to that, never enough. But in Workmen's Compensation Act, there's a specific exclusion, Section 35, specifically excludes attorneys to represent workers unless the Commissioner agrees to the fees of the attorney, which the Commissioner never agrees to. And that's why workers never receive compensation, and the system is in chaos. And that is a system where there's a legal obligation on the employer to see to it that the workman's claim is lodged and pursued. Now, with RAPS, consider the absurdity. The so-called insurer is going to do its best to make sure that it pays the claimant the maximum. Currently, the Road Accident Fund fights every claim tooth and nail, even if the merits are 100%. Even if there's no question. The victim's in a stationary car struck from behind at a traffic light. It fights every claim tooth and nail, even though there are attorneys involved. What possible hope does a victim have under RABS of receiving even the negligible compensation that applies in terms of the Act? It's really bad news for road accident victims.
Can I maybe just comment on that? I think that's an unfair comment. Definitely the Road Accident Fund does not defend every claim. And it's not as simple as someone driving into a motor vehicle and we're saying that we're not liable. What we have under the current dispensation is someone sustains an injury, he's represented by an attorney, the person is a young person, and in every claim, let me not say in every claim, but in most claims, there's then a claim submitted on the Road Accident Fund for loss of income. Now that loss of income is determined with regards to various expert reports that make an assessment of what potentially this person could become, having regard to, for instance, what his or her parents achieved in life. So, if you have two doctors as parents, the assumption is you would have become a doctor. If you have two blue-collar workers as a parent, the same applies, which is obviously not true in every instance. So, obviously, we cannot concede to every claim coming in without applying our minds and assessing whether there is indeed a claim. And from, again, the 25% contingency fee plays a huge role in terms of driving especially the damages for loss of income. Because of the current scheme where we pay a lump sum, and the attorney has got that vested interest to settle for as high an amount as he possibly can.
Because that benefits the client.
And the attorney.
The question I want to ask quickly before I see we've got a few minutes left on this discussion. The question is, in the media statement released early this month by the RAF, it was patting itself on the back for being awarded the Minister's Special Award. Congratulations, by the way. But was the award for an organization, why the award for an organization that is struggling with a huge deficit?
You must understand that the deficit is we have little control over. The fund receives its income via fuel levy, and it's required to pay compensation, and there's no link between the two. What we have been able to do is reduce the outstanding claims through efficiencies. So we are settling more claims, we are reaching more claimants, we are assisting more people with compensation.
Well, we've actually quickly run out of time, Jim, and I wanted to give you each time to say your last word, but unfortunately I have to wrap. This has been Rights and Recourse. This program is repeated at 10 tonight and at 5 on Monday morning. From all of us in the studio, thank you to our guests and good afternoon. And thank you for all of being part of the program and wishing you a safe, festive season. Stay safe and don't drink and drive.
Guinea is reopening an Ebola clinic in its remote southeast in an effort to prevent sick nationals seeking better treatment elsewhere.
The new labor law also seeks to clamp down on violent strikes by holding a trade union liable for violence committed by its members during a strike.
The new canal is set to boost annual revenues to about $13 billion by 2023. It's part of a larger project to expand port and shipping facilities around the canal.
This is Vigigas's fourth victory on the PGA Tour.
That's all the weather that I have for you for now. Stay tuned.
For all your business news, catch news at 1 every day. Be informed.
This former breadbasket of Africa, playing host to SADC leaders.
I feel humbled and yet greatly honored at being appointed the chairman of SADC.
When I was a student, Harvard was only my visible college, my formal classes. But I was also a student in an invisible college.
The outbreak in West Africa is the world's deadliest to date. It's centered on Guinea, Liberia, and Sierra Leone, with cases also reported in Nigeria.
Catch news at 8, 7 days a week. Be informed.
You look nicely dressed, PAC colors, you are not in agreement. Why was the president not allowed to address conference?
Even when he was given an opportunity, he did not stand up and say, look, I don't recognize this conference.
Why didn't you do that, Mr. Mpeti?
I was never given any opportunity to speak there.
Mr. Mpeti cannot come to the studio and complain about what transpired in the conference.
Did you say, Banna, I will pay for the PAC. When time comes for you to pay back the money, you will pay me back?
Yes. He is lying here.
That money is mine and I did not get it back.
This information,
and I want it
this
even
information
now. Is he's a deputy there. They took 430,000 without me. He said he's the general secretary, he's the accounting officer. Where on earth can the general secretary be the accounting officer? Yeah? It's what he did.
We'll come back. Watch Question Time with me, Mpho Tsedu, Monday to Thursday at 5:30 p.m. on the SABC News Channel.